Today's session is all about notice periods. I'll be talking for about half an hour. Thanks for bearing with us. We started a little bit late today. In this half hour, I'm going to be delving into some of the law around notice periods and how to manage them to stay compliant and also protect your business. Today, I'll be covering the basics of notice. So how long should notice be? How should it be given? When does it take effect? All that sort of thing. Then I'll go on to consider some ways of managing notice periods. And there we'll be looking at payments in lieu of notice, garden leave. I'll be thinking about summary termination and when that's lawful, when it's not. And then we'll end with some key takeaways. And along the way, we'll be thinking about some of the practicalities of managing notice periods, bearing in mind the law. Notice basics. So I make no apologies for being really down to earth now. If you know all of this already, then perhaps this is a good reminder session. But some of the basics on notice can go wrong very quickly if you're not tuned in and you don't know what you're supposed to be looking out for. So the first thing is any employment contract can be terminated on notice, and an employment contract does not have to be agreed in writing, doesn't have to be in a document. However, all workers and employees are entitled to a written statement of their terms of employment no later than day one of starting work. And within those written terms, you must include how long a notice period is, so how the employment would be ended. So giving notice in employment relationships there are no particular requirements to this. It doesn't have to be in writing. It doesn't have to be by letter. It doesn't have to be under seal. It doesn't have to be in a particular form of wording. It can be done verbally. It can be done in writing. If the contract of employment that you're working with specifies how it should be given, then of course you must follow those requirements. Otherwise, there are none in particular. The most important thing is that clear words are used. So being vague about what you mean is always a recipe for disaster in any employment context. Saying, I don't want to see you here at work tomorrow would not be clear enough to be the notice of termination of employment, for example. And so more often than not, it's very important to go into writing to make sure that the employee has understood the clarity of the situation. There's no room for uncertainty. Uncertainty tends to lead to claims or certainly disputes in my experience. When does notice take effect? Well, that will very much depend on the length of the notice period. I'll come on to that in a moment. But if somebody's contract specifies 1 month's notice and I give notice on today's date, which is the 13th of November, that notice period will end on the 13th of December. And so the notice, when notice is given, takes effect on when it's communicated. So the giving of notice is on the day it's communicated. And the day that the notice comes to an end, that takes effect on at the end of that notice period, whatever that is. And so coming on to length of notice, well, you may be aware that there is a statutory minimum period of notice, a legal minimum that you cannot go below in your employment contracts. However, you can specify longer periods of notice in the contract. The statutory minimum is 1 week after a continuous period of 1 month employed, rising to 2 weeks at a completed 2 years of employment, and then an additional week per every year of employment, up to a maximum of 12 weeks. Because you can't go below statutory minimums, if your contract simply says 1 month's notice and doesn't specify anything beyond that within the legal requirements, then it will be unlawful. If you only give that 1 month's notice when you want to terminate employment, there will be a claim for wrongful dismissal and breach of the minimum notice requirements. So do pay attention to that. Make sure your contracts are compliant. And then coming on to notice pay. Well, what should somebody be paid if you issue notices of termination of employment? Well, it's quite simple. It's how much they would normally earn or have earned during the notice period. If their earnings are fixed, if they earn a salary or a fixed weekly wage because of fixed hours of work, then and there's no variable elements like commission or overtime, then it's a simple calculation. If pay varies, then you will be used to calculating average pay for other purposes, and you do exactly the same if you're calculating, for example, payment in lieu of notice. And I'll come on to think about that in a little while. But if they're going to work out their notice, then they'll simply get paid for the hours and the commission or variables that they earn during that period of time. Here I'm saying that although there is a statutory minimum of notice, reminding people that you can set longer notice periods. And in fact, it's quite normal to have significantly longer notice periods for very key employees, not for everybody by any means. And for junior hires, it's quite unusual to have notice periods that extend beyond a month initially and then rising with statutory requirements, or 3 months. For more key and senior individuals, you might be looking at 6 months or even 12 months for the very senior people, chief execs, for example. And there is a relationship to be had here with restrictive covenants. So restrictive covenants may appear in your contracts of employment already, or you may be thinking of using them for particular employees. Again, they shouldn't be used as a sledgehammer to crack a nut. They're not a blanket thing to put in every contract. They must be tailored to individual roles. And notice periods are relevant here because one of the tests for whether a restrictive covenant is reasonable and doesn't go beyond what it's intended for is to look at the length of time that that covenant lasts for. So typically it might say in a contract you are restricted from working for a competing business for 3, 6, 9, 12 months after your employment ends. Now, if the employee in that contract is only required to give a week's notice or be given a week's notice of the ending of their employment, a 9-month restriction period would look grossly excessive there. So there has to be a relationship with their notice period to some extent. Why? Because the purpose of a notice period and the restricted covenant is to protect business interests. Notice periods allow for a period of transition. They allow the business to recruit. They allow transfer of knowledge, handover of role and responsibilities. But they also give an opportunity to protect key business assets from an employee who might be a threat to the business. Well, that's very similar to a restrictive covenant. And so if you have a very short notice period, it indicates to a court who might be called in to assess a restrictive covenant, whether it's enforceable, it would indicate to a court that actually the business doesn't consider this employee to be particularly key because it hasn't got a very long notice period. So that's something very important to think about when we're thinking of notice periods protecting the business. Now, withdrawing and waiving notice, sometimes this gets confusing and employers think that they can waive notice requirements or they can shorten notice without there being any consequences. Once notice is given by either party, whether that's a resignation by the employee or they're being dismissed, they're being terminated by their employer, that notice cannot be withdrawn unilaterally. It is, under the terms of the contract, a contractual term if notice is given and it is accepted by it doesn't have to be accepted by the other party. It is served in line with the contractual requirements. It cannot be withdrawn unless there is agreement between both sides. So that would have to be done by mutual agreement. And similarly, waiving notice requirements. So if employee says, I have a job, I'm leaving, I don't want to serve my notice, well, it's not within their gift to say so. That's a breach of contract if they don't give the required notice. And it will only become a lawful act if the employer agrees to waive the notice requirement. Sometimes when employees are being settled out of employment, there might be an agreement that notice is waived in those circumstances. It's very unusual for an employee to waive their notice entitlement because, of course, it means loss of money to them and uncertainty, of course. Now, holiday periods during notice taking holiday during notice periods is sometimes a grey area. So all employees are entitled to statutory holiday. The rules that govern statutory holiday are different to, for example, additional holiday that you might provide for under the contract of employment. Now, the statutory holiday rules say that you can require employees to take the remaining statutory entitlement during their notice period. Any additional contractual holiday, well, the rules regarding that would have to be set out in the contract. So if you want as a business to insist that employees take all of their holiday, use it up, so you're not paying in lieu of accrued holiday at the end of employment, then make sure that your contracts are clear, I would say, on both the statutory and the contractual elements. Any holiday that isn't taken during the notice period, the statutory element, employees are entitled to be paid in lieu of that on termination. And again, if there's any additional allowance, then the contract will have to specify what happens to that on termination. Sickness and statutory leave during notice. There are special rules about notice pay for people who are on sickness or statutory leave. Statutory leave is maternity, paternity, adoption, that sort of thing. So for these types of leave, there are some peculiar rules, and I have to admit that I have to look it up every time I need to explain how they work, because it is a really weird loophole. But it all comes down to how long the contractual notice period is. And if the contractual notice period is not much longer than statutory minimum, so let's say that you've got an employee who's been employed for 3 years and they have a 4-week notice period, then you would have to pay their normal pay for the statutory period of notice. So for somebody who's been with you 3 years, their statutory notice entitlement is 3 weeks. They'd be entitled to 3 weeks of their notice at normal pay, and the remainder can be paid at their sickness rate, whether that's SSP or company sick pay. And the same applies for statutory leave. It's a peculiar rule, and it is something you need to look at carefully, because it might make quite a difference to payments that are due to somebody who is leaving, who is off sick or absent on family leave. Summary termination and resignation. So normal rules apply unless there is a right to terminate an employment contract lawfully by either employee or employer. A termination without notice, summary termination, will be unlawful. It'll be a breach of contract. For the employee, it probably would mean that they have a claim for wrongful dismissal as well as breach of contract, because wrongful dismissal is dismissal without notice in circumstances where the employer is not entitled to do that. So, what are the lawful situations where you can dismiss without notice or terminate without notice? The first one is a gross misconduct situation. So if there is theft or bullying, harassment, discrimination, or other types of gross misconduct, and you as an employer have decided that that has taken place and it is serious enough to warrant a gross misconduct dismissal, then you're entitled to dismiss without notice or payment in lieu of notice. Note there that the consideration of whether you are lawfully entitled to do that might be made by an employment tribunal if the employee challenges it and brings a claim for unfair dismissal. Currently, they are not entitled to do so until they have 2 years continuous employment. That is going to change. We're not sure exactly when, probably 2027, and you may know already that that's going to come down to day 1. So for now, no challenges for unfair dismissal under 2 years. That will change in the future. If you want to keep up to date with those changes, we are sending out regular newsletters on various topics that are within the Employment Rights Bill. Sign up to our newsletter on LinkedIn for more information. The second lawful scenario for summary termination is where an employer gives notice, or possibly the employee gives notice, wants to resign, and there is a payment in lieu of notice clause within the contract of employment, and the employer relies on that and terminates immediately, but makes a payment in lieu of the full notice period or part of it. That is perfectly lawful. It won't create an unfair dismissal situation. It won't create a breach of contract situation, as long as there is a clause in the contract that gives the employer the right to make a payment in lieu of notice. That notice has to be fully taxed, and NICs have to be paid on it, whether or not you have a clause in the contract. But if you don't have that clause in the contract that gives you that right, making a payment in lieu of notice will be a wrongful dismissal. It will be a breach of contract. Likelihood is, if you're compensating the employee with their full earnings for the notice period, you're paying the damages that would be due anyway. So it's a small point, but you might find that that breach of contract has other consequences, which I'll come on to in a short while. Resignation without notice is a scenario that's very specific. So I'm not talking here about an employee who goes AWOL and just decides to leave their job. They don't give any notice, they've found another job, or they've just decided they don't want to work for you anymore. That would be unlawful, be a breach of contract. Resignation without notice is justified and lawful in what I've called a constructive dismissal scenario. And that is where the employer has acted in such a way as to seriously damage the relationship of trust and confidence in the employment relationship, or has broken one of the very fundamental terms of the contract, such as changing role without consultation, demoting, increasing responsibilities without pay, dropping salary, things that are truly fundamental to the employment relationship. If in that scenario the employee decides, I'm not having this, I don't agree with it, they can resign, but they must do so usually without giving notice, and they must make it clear why they're resigning in that situation. And then it would be for them, the employee, to bring a claim of constructive dismissal to the employment tribunal and have that determined by a judge. And as the employer, there will be a very, very big risk of that claim being successful in any of the scenarios that I have painted. So that is one to be very aware of if there is a brewing dispute, a grievance situation, somebody's complaining about the way they've been treated, bullied, maybe harassed, they think their treatment's been discriminatory, and you are heading into a scenario where they might resign at the end of, say, a grievance process or a consultation about their pay responsibilities. If you are in those waters, then taking legal advice early would be my suggestion. So we mentioned payments in lieu of notice, usually referred to as PILONs. What is a PILON? Well, I've explained earlier that it is a payment instead of working the notice period, either in full or in part. That payment must reflect what the employee would have earned during that notice period. Why use it? Well, there are several reasons why you might want to use a payment in lieu of notice. You may already have recruited a replacement for the employee who's leaving, and you just might want to bring their employment to an earlier end because you want the other person to start. You might want a troublesome employee to be out of the workplace as soon as possible. You might fear that they could do damage to relationships or to the operations of the business. They might be a threat in terms of competing with you. There might be a threat in terms of taking information to start a competing business. So these are all good reasons why you might use a payment in lieu of notice instead of an employee working out their notice. So in those circumstances, you really need to check when you have people starting at the beginning of the employment relationship that your contracts include a payment in lieu of notice clause. You'll remember earlier I said if there's a payment in lieu of notice in your contract, then you have the right to terminate summarily. That's exactly what we're looking at here. If there isn't such a clause in your contract, you're making a non-contractual payment in lieu of notice, that is a breach of contract. It's a wrongful dismissal. And whilst you may well pay the employee what they're owed, the compensation for that breach, the effect, it could have a very damaging effect on ongoing obligations under the contract, such as confidentiality by the employee to the business and restrictive covenants. So this may not apply to all employees because they may not all have restrictions in their contracts, but for those who do, whether it's 3 months, 6 months, 9 months, 12 months or beyond in their contracts on termination, you want to be able to rely on those restrictions. And so you must make sure that you have a payment in lieu of notice clause and a garden leave clause. I'll come on to that in a moment. Those are fundamentally important things if you are wanting to rely, possibly may want to rely on the restrictive covenants at the end of employment. So, as I think I've mentioned already, the effect of making a payment in lieu of notice is to bring to an end the employment immediately. So if today, on the 13th of November, I decide I'm going to terminate Hamon's employment with Burley Law, I'm going to issue notice. I'm not sacking her for gross misconduct, but I'm issuing notice. So that goes into writing. And on the same day, I decide I don't want Hamon to work all of her notice. She's going to work 2 weeks, and then the remainder is going to be paid in lieu. The effect of that, which I will put into writing to her mom, will be to bring forward her end of employment date. So she will work 2 weeks, during which she stays employed, and at the end of that 2 weeks, her employment will come to an end, and she'll be paid for the remainder of the notice period. So it's quite simple. If I wanted her to leave today, 30th of November, today would be the end of employment date. She'd be paid in lieu of the notice period in full. Now, there's a risk for employers, as I've said, of breach of contract and wrongful dismissal claims if there's no contractual right to make a payment in lieu of notice. There's also a risk of restrictive covenants being null and void if a payment in lieu of notice clause doesn't exist. And very importantly, payments in lieu of notice are taxable in full, and employer and employee national insurance contributions must be paid on them. There was a time when, if there was no clause in the contract, a payment in lieu of notice payment would have been classed as damages and not taxable. Those rules were changed several years ago, and so it is no longer possible, even under a settlement agreement, for a payment in lieu to be classed as an ex gratia payment and non-taxable. Now, garden leave is another way of managing a notice period, but it's different to a PILON. With a PILON, you bring employment to an end immediately. The employers are then out there on the labour market, free to do what they want, free to damage the business name, put nasty things about you on Facebook or their other social channels, compete, do what they want. Garden leave operates differently. During garden leave, that is the whole of their notice period or part of it, the employee remains at home. They're not required to work. They are not allowed to have contacts with customers or colleagues unless authorised to do so. And they get paid. So they remain employed during their notice period for as long as they're kept on garden leave. And you might use a mixture of two things. You might do some part of the notice period as garden leave and the rest as payment in lieu. But it would be very unusual to put somebody on garden leave and then bring them back into the workplace for the rest of their notice period. You'd either put somebody on garden leave for the whole or part garden leave, part payment in lieu. And that's perfectly lawful to do either of those. But again, for garden leave, you must ensure that you have this right in the contract of employment, because again, the same risks apply. If you don't have that right written into the contract and you use it, you impose it on an employee, you don't do it with their agreement, then that'll be a breach of contract. And it might jeopardise those restrictive covenants and confidentiality obligations that you want to rely on going forward. So, often used for very key personnel, used sometimes for very customer-facing roles where you want to protect those relationships and put somebody else into dealing with the customer to make sure that that contact is safe, that you don't lose the business, because if the employee were to go immediately or to continue having contact with that customer, they're going to warm them up for the role that they're moving on to. Now, those are all good reasons why you might use garden leave. You might also have a situation where an employee is in severe conflict with the business. There has been a dispute of personality. There's been a messy grievance. There's been a very messy disciplinary or performance management process. And those too are good reasons to use garden leave, to get the employee away from the workplace so that you can focus on building back up the business from whatever's take place. Effect on employment date I've already covered. Well, the employment doesn't come to an end sooner. The notice will take effect and employment will end at the end of the notice period. The employee remains employed throughout the period of garden leave. Well, we know that both PILON and garden leave are costly because effectively you're paying your employee for not working, whether you're paying in lieu and giving that's a lump sum that's going to the employee, or you're paying them to sit at home and do nothing. That's a costly decision for the business. It has to be used carefully. And I've also already covered these other potential risk areas. I didn't talk about constructive dismissal earlier. That is a possibility. You know, if you put somebody on garden leave, particularly if it's a long garden leave, a long notice period, there could be a claim of constructive dismissal. It's a breach of contract. If it's not in your, if it's not covered, the right isn't in your contract of employment, you impose it on them. It is a breach of contract. It is fundamental because they're not able to work for that length of period, although they are being paid. They're restricted from going out and looking for work. They're not, going to have a sort of a gap in their skills and experience. And that probably would amount to a constructive dismissal. If they were leaving anyway and they're simply serving out garden leave before they go to their next job, well, compensation for constructive dismissal is likely to be limited. But nonetheless, it's an aggravation and a claim that's going to cost the business to fight. So having garden leave as well as PILON in your contracts is really, really important to avoid some of these really messy situations that could get costly and litigious. So I'm going to end with some key takeaways for you. Always review your contract of employment before you give notice. Follow the contract. Follow what it says. If you're concerned that your employment contracts may not be compliant, well, what about doing a review of those now, making sure that you've got the garden leave and the payments in lieu and that they're worded appropriately and that your notice provisions are compliant and that you have appropriate notice periods for different levels of employee and that you've considered restrictive covenants appropriately and tailored them so that everything ties together when you're ending employment and you want to make sure that the business is protected. Confirm notice in writing, always really important. I've seen some cases where clients have not confirmed in writing. I've had them very recently where they came to me and they had sent an employee home for effectively stealing confidential information. They hadn't been clear why they'd sent them home, whether their employment was terminated or not. So, and they hadn't sort of followed any kind of process for that. As the lawyer, I then had to come in and spend a fair amount of time drafting the letter, explaining why the decision had been taken, that they had committed gross misconduct. But that, that's an expensive way of doing it. Get a lawyer involved if you must. But if you can do this yourself, you're going to spare the business that cost. And of course, it's good practice and it's setting the right tone for your HR generally to make sure that these things are done at the right time and in the right way. Calculate final pay and don't forget that you will need to include holiday if holiday isn't being used up during the notice period, and any benefits that might be accruing during the notice period need to carry on. If you're making payments in lieu of notice, then you might have to calculate the value of benefits and add that into the payment in lieu, and that will depend on how your payment in lieu of notice clause is worded in your contract, whether it's tied in only to basic salary or salary plus benefits. And of course, if you don't have a payment in lieu clause, then you're going to be liable for the lot. Consider PILON and garden leave carefully. Make sure that they are included in the right way within the contracts. I've got some useful resources for you today. As always, and I always flash this up, the ACAS website is useful. It's got guidance on all sorts of things. It's fairly basic level, but it will give you the nuts and bolts of notice. There is a guideline on there, and it'll get you started. And there might be some useful templates there. The ACAS Code of Practice is always something I refer businesses to because it's really important to ending employment. It doesn't tell you a lot about notice, but it will tell you what process you must use if you are considering dismissal or any kind of disciplinary process that might impact on the employee's continuity of employment. Our YouTube channel is full of valuable resources. It's like a treasure trove. There are podcasts on there where I talk to guests about healthy workplaces and related topics. And of course, as I said earlier, you can catch up on our previous webinars there. And today we have a free resource for you, which we'll send after this webinar finishes. It's a checklist on managing notice periods. So it covers some of the ground I've gone over today. And that is the end of our session on notice periods. Our final Lunch and Learn of the year will be on the 11th of December, and we'll be looking at protecting business assets. We'll be picking up on some of the themes we've talked about today, confidentiality, restrictive covenants, and other areas too. So join us on the 11th of December. We will send a reminder out nearer the time. And just to cover off some of the compliance stuff, I want to just flag that we have bundles of compliant documents. These are really important for your business. They don't just come as a bundle of documents, but they come with 6 months ongoing support with our team so that you can have time on the phone with us or by email to get supported in how you're using those documents and any other issues that might crop up during the 6 months. We have a starter bundle, which is suitable probably for businesses up to around 10 employees. Simple, basic policies that get you started, plus a compliant employment contract, offer letter, an intern agreement, a starter form, and an NDA. For growing businesses who've got more than 10 employees, our scale-up bundle, that'll give you more documentation, a much more comprehensive handbook for a larger workforce. But again, that 6 months ongoing support is available. And for 12 months after you buy either of these packages, you will get templates, one a month, like the checklist that we're giving away today. Really handy key resources, templates, flowcharts, checklists that will help you with your day-to-day HR. Thank you for attending. These are my contact details. Do link in with me. Do follow us on LinkedIn as a company. And if you've got any queries at all, just email them over to me at my email address there. Thanks for attending today. And if there are any questions, we'll stop the recording now.